thank you to especially to SCCCI and for giving us the opportunity to speak and meet with everyone today. So today we'll be talking a little bit about debt recovery for businesses. So I'm going to use my slides. So I'm going to share the screen. Right, okay, so this is a short overview of what the different things we'll be talking about today. Steps in the debt recovery process, differences in each process, cost of court proceedings, costs, so this is something that people are very concerned about. If I spend all this money on legal fees, can I get anything back? Well, the short answer is yes, and we'll go into some detail into that. And enforcement of court judgment. So this is something that is distinct. So there are actually two main stages before you can actually get your money back if somebody or some company doesn't pay you back. First, you've got to prove that this company owes you this money, prove to the court. And then once the court is satisfied that this company owes you money, it'll allow you to enforce it, which is to give effect to that judgment. And that's enforcement of court judgments. Some important terms to be included in IOU, this is something that where people try to settle among themselves to say, okay, I owe you this money, I'll sign something. We just talk a little bit about what should go into those documents. Right, okay. So what is the process? Now, this is a short, simple flow chart that I came up with to explain to clients how this process works. Now, the first step is what I call the universe of client action. Now, this is everything that the client does. It can take any form, calling your debtor saying, please pay. It could be visiting their premises. It could be taking them out to dinner and saying, right, can you please pay us? All of that stuff. Now, everything, and the key thing is done by you as the client, rather than a third-party law firm. Now, most of the time, this works. Most of the time, I'm sure your debtors will pay you. Now, what happens where for there's maybe that minority of debtors who refuse to pay, despite all the calls from your admin and finance team, and maybe the management tried it already. You tried everything, and they don't take any action. Then this is the next stage where we suggest is what we call a letter of demand, a letter before action. Some people just know it as lawyer's letter. Yes, we usually suggest this as a starting point, as a prelude to actually suing them in court. Note that in this letter of demand, you haven't actually sued anybody yet. It's a letter from a third party, from our law firm. So very often we get this question: what is the significance of a letter of demand? What happens if the other party ignores it? Yes, they are free to ignore it. Now, but what the letter of demand signals to them is that you are serious about paying, about taking action to claim this money back, and then you are not going to send them any more action. So you've referred the matter to third-party professionals. You're saying, right, we've tried everything nice, and they're not paying us. So it's a last chance for the clients, for the other creditor to make payment without resorting to formal legal proceedings. It's a strong incentive for people to do so. Why? Because legal proceedings are costly for both parties, and they should really think about it before. They should try to exhaust all ways to settle it before making this a legal matter. Now, if that doesn't happen, then unfortunately you've got to go to legal proceedings. Now, that's that third stage here. Now, legal proceedings is, you can understand it loosely as proving your claim in court. It means you sue somebody, and then you have to provide evidence that this party, for example, you sold goods to them, you sold things to them, and then and now they can't refuse to pay, and now you have to prove it to court to pay. Now, finally, when you establish that these people owe you this money, and then they still might not pay you, then you have to give effect to that judgment by going for enforcement proceedings. So this is a broad stage, overall view of what happens. How do we get our money back? Now, you can see that very often you get stuck at the universe of client action because you've been calling, you've been asking them to make payment for months, sometimes even years, and the other party just refuses to make payment. Now there's this flow chart going down the line. You see that there's a final resolution to it. There's an ending to it, that where the judge or the court says this party owes you this amount of money, and then there's closure to it. Now, this enforcement proceedings is, now very often at this point, we get questions from clients and say like, okay, this is the legal process and it takes a long period of time, it costs money. Why don't we go for what is commonly known as debt collection agencies? Now, the last stage here, enforcement proceedings, is the key difference between going the legal route, going through the court process, and going through these so-called debt collection agencies. Now, the important thing to remember is that they may call themselves debt collection agencies, but they don't have any special powers. You know, they are still reliant on issuing letters or visiting the debtors at their premises and things like that. They cannot intimidate, they cannot threaten, they cannot harass debtors. If when that happens, they can call the police on them. And so it's really not that different from what I call the universe of client action. It's really the same things that you do, but they do. Maybe they just look a little bit more intimidating or fierce, but they cannot actually intimidate the debtors into paying up. So we'll come back to enforcement proceedings in a bit, but this is an overview of it. Okay, so now let's say you've issued a letter of demand. So this is a bit more detail of how it works. So this is, when I put chase them one here, WhatsApp, email, call, this is what the client action is. So you've tried this and it doesn't work, then you try a letter of demand from a law firm, a third-party professional which comes in to signal to them. What you're hoping for is this, settlement negotiations. What you're hoping for is that the other party will come forward and negotiate and offer to make some kind of payment, or whether in part or in total, or maybe they will say, well, hang on, you say we owe you $100,000, but it really is $80,000 for these reasons. It's good to know those reasons because objectively they may be valid reasons, and the job of your advisors, your legal advisors, is to say, are those things that they raise relevant? Will they be able to prove them in court? So you get a little bit of a preview of what the other party might say should you decide to commence any actions. So this is settlement negotiations. Now, very often we get some kind of negotiation, whether is it to pay by installments or whether the amount they feel is wrong, things like that. So that would evolve along the way as and you have to react to it, because ultimately debt recovery, we call it debt recovery, but it's litigation. It's a dynamic process. What do I mean by that? It means that one party takes an action, and your next action will depend on what the reaction, or if there's no reaction from the other party. So this is the job of your advisors to say, right, okay, what are they saying? Is this reasonable for them to say this? Would that be able to hold up in court, for example? And we'll come back a little bit into a cause of action. We'll discuss it in a bit more detail. Okay, so let's say you tried letter of demand and stubbornly these debtors have refused to pay you. Then you may have to consider going to court proceedings. So here's a breakdown. The next slide here is a broad breakdown of what happens if you decide to commence legal action. So we have here the letter of demand. So you've tried this, they say no, okay, or they have no response, they refuse to respond to you. And then you have to go on to the court proceedings. This is an example, for a general example for things like sale of goods, services, unpaid services, unpaid loans, or this kind of thing. So you normally start it by issuing a writ of summons and a statement of claim. This is filed in court and then served on the other party. So this is where it is, service of documents. Now, service of documents is an important part of the court process because the court requires that the other party knows that you are commencing an action against them. So you need to let them know. So you need to file your claim, which tells the court what exactly your claim is. Now, this is important because the statement of claim is basically your case, and everything flows from it. The documents that you provide, the witnesses that you call, eventually flows from a statement of claim. So that's why you've got to get this right, because you point it in the right direction, and then it must be a valid claim as well in law. So let's assume that's all sorted out and you serve the documents on the other party. Now, service of documents is always tricky sometimes, because where you have, let's say, a individual debtor who is trying ways and means to evade service, means you don't know where they are, you don't know their location, then it makes it difficult for you to serve documents on them. There are alternatives. The court allows what is known as substituted service, because in case you cannot find this person, the court will allow you to serve it on its last known address, for example, or is in certain circumstances, you can even serve it by email or WhatsApp. But all these are not the standard forms of service. You need to go to court and ask for permission from the court to do it this way. So let's say you have filed your claim and you've served it on the other party. Now the ball is in the other party's court. What do? They are obliged to enter an appearance. They have normally 8 days to do it. And then after that, they have to enter a defense. Now, if they don't do any of these things, you can enter default judgment against them, which is kind of like football, where one team doesn't show up to play and then you award the win immediately. Now, anytime you get judgment, you can go into enforcement proceedings, and we'll come to that in a moment. So this is the broad overall approach to it. Now, sometimes people are reluctant to commence court proceedings. Why? Because if you follow through this whole thing, and if you ask most lawyers and you say, let's say for a relatively smaller claim, below $60,000, which is commenced in the magistrate's court, you might typically spend $25,000, $30,000 up to here, which is a fair sum of money. It's quite a lot of money. Now, nobody wants to spend $25,000, $30,000 to recover even a $50,000 debt. Now, the thing is, most cases, and the vast majority, like 80%, don't ever reach the hearing stage here. The hearing is where you see on TV where people cross-examination and they make courtroom dramas out of it. Most cases actually settle at here, mediation. Now, typically, you will not have to spend so much money if you reach up to mediation. Now, you can see that the cost of commencing a legal action is relatively small here. Writ of summons, statement of claim is smaller here. Appearance and defense are the other party's costs, and then you come to mediation. So at this point, you haven't spent that much in legal fees yet. And then there's a good chance that you might be able to settle it, because even if the debtor ignores a letter of demand, it's quite rare that they will ignore a writ of summons. Now, even if they ignored it, your cost won't be high, because you can go straight to default judgment. So your cost isn't high. The main cost of legal action is incurred here: documents, witness statements, and a hearing. So given that most of the cases settle at mediation, you can see that you don't spend $25,000, $30,000 at one go. You spend a little bit at the beginning, and as you go along, a bit more at mediation, a bit more at documents, more at witness statements, more at the hearing. So you can see that parties are incentivized to settle early, because the costs sort of go up as you progress along the court proceedings. So with that increase in cost, you also can see that the debtor is very unlikely to fight you all the way if there really is no real defense to the claim. Nobody wants to spend we're betting that they'll act rationally, and they won't want to spend $30,000 to defend a $50,000 claim in which they have no chance of winning, because whenever judgment is obtained against the losing party, they also have to bear a portion of their costs, of their legal costs. So on top of the, say, $50,000 that the debtor owes you, if you get judgment in your favor, whether it's a default judgment or final judgment here, you also get a portion of your legal costs awarded to you, which you can recover from the debtor as well. So when you start proceedings here, very often, these are the court actions, but along the way, you can imagine, in parallel, parties will still be negotiating and trying to settle the matter before it reaches an advanced stage of the hearing. So there you can imagine two concurrent actions that are going at the same time. One is the court proceedings, which has its own timeline, and the other one is a settlement proceedings, which will run concurrently. And at any time you reach settlement, parties can discontinue the proceedings in court. So this a typical letter of demand for a basic one typically runs you a couple of $100, and a writ of summons and a statement of claim, depending on complexity, typically runs in a few thousand to several $1,000s. So these costs are much lower. Like for example, by the time you reach a hearing, you may be spending like $5,000 a day, and so it really adds up at this stage. So what I'm trying to say is that it's a step-by-step process, and the party which is willing to follow through on this process will put pressure on the other party. So sometimes so when you chase your debtors, you put a bit of pressure on them. When a law firm issues a letter of demand, that pressure goes up a little bit more. When you issue a writ of summons statement of claim, the pressure increases even more. As it progresses along, if they don't do anything here, of course you get judgment. But let's say you follow along, the pressure goes up. Now you want to provoke a reaction from your debtor, and that's why if you start with a small amount of pressure and you get reaction, good, you can settle it fast. Some debtors are more stubborn; you need more pressure to invoke a reaction. It isn't always the goal to follow through the entire process and spend tens of thousands of dollars on legal action. What you're hoping and what you're betting is that the debtor will come forward and settle up with you. It's to everybody's benefit, really. Because, for example, when you start a writ of summons, a statement of claim is filed and served on court, these things actually show up in ACRA searches and credit searches. If they have existing loans, they have existing credit facilities, the banks routinely scan through for commencing whether action has been commenced against them. If the credit rating of that particular company is not great, the banks will actually call them up and ask them, hey, what's this claim that you've got against you? So it's not just, it's a variety of forms that this pressure takes. For example, if they want to tender for work, in the case of construction companies, commencing an action puts pressure on them as well. So once you issue a writ of summons, you've got a good chance. Okay, so let's talk about two different kinds of companies. Now, one kind of company is one that has a decent operational business going. Now, they don't want that kind of disruption to them. They don't want their credit lines to be affected. They want to be able to tender for jobs. For example, if they were a construction company or any account company, you want to tender for government jobs, you don't want to have to explain why is your supplier suing you for this money. So because owners don't want that kind of thing. They don't want a company that has a lot of litigation against it. So, and then the banks will ask questions as to why is there all this action. So you can see that multiple things happen at the same time, and to put pressure on a debtor to react and to come to the table, essentially, the negotiating table to settle. Okay, so we'll move on from here. So this is a short summary of the different courts that exist in Singapore. So this is the Small Claims Tribunal. It's quite popular for claims that are below $20,000, and but then lawyers can't represent you at the Small Claims Tribunal. So you need to spend your own time to file the claim and get it right, and go and attend the hearings, which may be quite tedious. Now, when the claims go bigger, up to $60,000, you go to the magistrate's court. Just to clarify, if it's below $20,000, you can still go to the magistrate's court because the Small Claims Tribunal does not hear all kinds of claims. So you have to submit the details of a claim, and then they will confirm if they will actually hear it. So as the amounts go up, you go up the seniority of the court: district court, high court, court of appeal. The main difference is in the complexity of the matter and the size of the dispute. For example, disputes relating to company directors and things like that, you only can hear it in the high court. But for debt recovery, you just go on the numbers here. Now, of course, if you get a judgment that's against you, as you might know, you can appeal a judgment, but there's limited scope for appeal. And generally, you can't introduce new evidence in the appeal. But this is something that you should discuss only if you, maybe with your lawyers if you need to. Okay, so yeah, this is just a recap of small claims tribunal and the magistrate's court. So remember that the time frame for small claims tribunal is much shorter. Normally it's about 2 years. For the main courts, the limitation period is 6 years. So if you have a claim, outstanding debt that is too long, more than 6 years old, you may have lost the right to claim for it. So, but for this, you should consult your lawyers to see like what kind of claim is it. For example, sometimes you get a query on you have a house which has a defect, but the house is, you know, maybe 10 years old and the defect only surfaced recently. So the question is that when this action arose, it may not be, so you may not be caught by limitation period. We included a term here, all courts in Singapore encourage settlement, because this is something that happens very often when we're advising clients and we say, right, court has suggested settlement, and the client says, I don't want to settle because I don't want to look weak. Now this is settlement doesn't mean you're weak. If you settle on good terms, it just means you're clever. Because, you know, you save money, you save time, and here's the thing about settlement. You control a lot of the process. You can control the result. And the damage, if any, to the business relationship is controlled by a lot. If you go all the way in court and you fight it all the way in court, you know, feelings are hurt. People feel they are hard done by the other party. They spend a lot of money. They feel they can't back out, you know. And what you see, what we talk about very often is that how did this dispute even arise in the same place? It actually started when two parties came together and wanted to work on something. Whether you agreed to supply goods to somebody or whether that person agreed to supply services to you. That was a position of, it was a positive place where parties come together to work on something together, whether it's a sale of goods or anything. So it must have been a reason for that. And one of the ways that settlement works is to try and go back to why did parties begin that commercial relationship in the first place? There must have been a good reason for it, and maybe along the way things just got a bit messy, and hopefully you can resolve them. And sometimes these processes serve to sort of reset the relationship again and say, right, okay, put that all aside, now let's talk about it with fresh eyes, and how can we go back to when parties were actually willing to work together. Right, so let's move on to the next slide. So this is a bit of a repeat of the same thing. So, okay, so we talked a little bit about cost earlier. So if you sue someone and win, so important thing to know is that if you settle halfway, usually parties will bear their own legal costs. But let's say for some reason you fight all the way and you get judgment in your favor. Here's a short estimate of how much cost you can get. So this is for the magistrate's cost, which is below $60,000. This is the cost figure that the court awards. So it's usually not the same as the actual amount you pay your lawyer's fees. And you, as a rough estimate, is 2/3. So depending, let's say you go all the way to trial and you fight for a $50,000 claim, you might expect to get, as you can see here, maybe $10,000, $12,000, but you would have paid your lawyer maybe about $20,000. So you're still what we call out of pocket for a certain amount of money. Because there's a number of reasons for it. There's a tax, there is disbursements, and there's other things that will come in to increase the cost. Okay, so earlier on we talked about enforcement proceedings. Now this, as I mentioned, this is one of the key differences between going through the court process and relying on what we call as debt collection agencies. Now recall that debt collection agencies can't actually do much more than what any individual can do. They can write letters, they can make phone calls, they can visit and all that. But they can't do any of these things. Now, what are these things? What is the garnishee proceedings? Now, garnishee proceedings is order that is made against actually a debtor of your debtor. Now, it sounds complicated, but an easy way to understand it is, for example, they have a bank account. Now, when you have a bank account, basically the bank is saying, I owe you what is the money in your account, and anytime you want it back, I have to pay you back the money in your bank account. So let's say you have a debtor who owes you $50,000 and they refuse to pay, and you sued them and you got judgment against them. You must get judgment for any of these enforcement proceedings. Then you can garnish their bank account. So you need to know which bank account, where their bank account is. The court does not gather evidence for you, so you need to know this beforehand. So, and this is something that you might want to consider when you're entering into a commercial relationship. You want to know, how much assets they have, where their bank accounts are, and it's quite. Think of it as when you extend credit to someone, you're lending money to someone. So even if you supply goods without being paid first, you're extending credit, you're effectively lending them the money to buy your goods. Now, if you're lending them money, then I think it's fair to say you want to know a little bit more about where their assets are, where their bank accounts are. Do they have, goods or property that they can put up in case they can't pay? So garnishee, when you serve a garnishee on a bank account, you take the money that's in the bank account and you pay it to you directly. So that's a very invasive action. You're taking something which belongs to another party without asking them anything like that. So this is a very powerful tool that you have to give effect to your judgment, and that's not something that any debt collector can do for you. So that's something only the court can order. So the order is made, or let's say OCBC Bank, and you say to the court, like, this debtor has $50,000 in OCBC Bank. He owes me $50,000. I want you to order OCBC to pay me that $50,000, and that's the effect of that garnishee proceedings. Now, we have listed this like this, but please don't be mistaken. You don't have to follow this order. You can choose any one of them to give effect to your judgment. So which one you choose will depend on what knowledge, what information that you have on the debtor. So even before you commence legal action, your legal advice should ask you, or should discuss with you, do we know anything about this debtor? Do we know if there's any property? Do we have any money anywhere that we can seize? Otherwise, even if you get judgment, that's not the end of the story. So I'm going to scroll back. So this is the long route here. And even if you spend all this money here, let's say you're willing to spend $30,000 to get judgment, or if you get default judgment, that's not necessarily the end of the story. The judgment means the court agrees with you that this party owes you this amount of money, but you haven't actually gotten the money yet. So you need to take enforcement action in order to get that money out. So coming back here, so writ of seizure and sale, a WSS, or sometimes we hear it called, is go and lelong their belongings. So what is this? This is a seizure of movable and immovable property. So what's movable property? For example, cash, computers, things like that in a premises, in the home of the debtor or the office of a debtor. You can go in and seize it. Okay, when I say you, it's not really you, okay, because the only person who is given that power is a court bailiff. Is an officer of the court, and is empowered by the court to enter those premises, to seize those things, and then he can sell it, and then the money is paid to you. So you have a couple of things here that ordinary people can't do. First thing is you have power of entry. You can enter into a locked premise. So sometimes people don't want to pay their creditors. They hide in the home, they lock it. You can't just bash down the door. But if the court bailiff comes for that, they actually have the right to get locksmiths to open up the door and enter. So they have power of entry. In addition to power of entry, as the name suggests, they have power of seizure. Now, seizure is taking something without that person's agreement. So whether or not these debtors agree or not, the bailiff enters and takes away the property. It's very invasive. It's a very powerful message, and it puts a lot of pressure on a debtor to pay up. And that's why only the court bailiff can do that. No ordinary citizen can have that kind of power, because it's a big responsibility, it's a big power, and only can be granted when you have judgment in your favor, that the court has confirmed that this person, this party owes you this money. Then you will empower the bailiff to go in and seize it. So you can understand garnishee proceedings loosely as, you know, getting cash back. So of course, if they have a bank account, with the account money, you get cash back. That's the best result. And you get cash for the judgment amount, costs for the legal proceedings, and costs for the enforcement proceedings. So you get all of that. So if they have money in a bank account, it's a good result. But unfortunately, if they have money in the bank account, usually they settle with you. So it's something that you should discuss with your lawyers as well. So then writ of seizure is, technically you can sell those things and get money, but most businesses and individuals do not really hold their wealth in movable property like cash and things like that. So it's not always possible to get enough money for them. But what happens is that when the bailiff comes calling, it's a big form of pressure, even embarrassment to the debtor, and sometimes that is enough for them to pay up, or to at least come forward and make a genuine offer for repayment. We've had a lot of experiences where the debtor is very, very stubborn. They refuse to respond to letter of demand. They refuse to respond to the writ of summons. So we got default judgment. Only when the bailiff came to their office or their home, then they call up and say, okay, I'm ready to pay. It's unfortunately some parties are just really stubborn that way. But at least eventually the clients got paid. So it's a result in the end. So this third one, examination of judgment debtor. So sometimes what happens is that we have clients who say, look, they owe us a fair amount of money, a few $100,000, but I don't really have much information on where his money is. Now, the examination of judgment debtor is a mechanism that you can use to summon the debtor to court. And as the name suggests, you examine them in court before the judge, and they have to disclose information on their assets, like their bank accounts and their property and things like that. And if they don't, then they may be in breach of a court order. They may be what we call penal sanctions, and they may even be put in jail for breaching of that. It's not an easy, the court doesn't throw people in jail readily for that, but if they are very recalcitrant and refuse to cooperate with the court's directions, they run the risk of that. So that's a pressure on them to make sure that they comply with these directions. Now, the last one, bankruptcy and winding up, is also another form of pressure. Now, the thing to note is that it's not that easy to get cash straight up from bankruptcy. Very often, the threat of winding up a bankruptcy is more effective than actually the bankruptcy or winding up process. Why? Because if this person has multiple creditors, then there's a possibility that even if he goes to bankruptcy, you won't get a lot of cash back. But it's a way of putting pressure on them. Why? Because if you are threatening to make, let's say, someone who owns several businesses bankrupt, the effect of bankruptcy, amongst other things, will prevent him from being a director of the company, for example, or multiple companies. Now, if you're not a director of companies, you cannot be a signatory to bank accounts, you cannot manage the company, you cannot do a lot of things. So you lose control over it. So it puts a kind of pressure on them to come and bargain with you. Winding up a company, same thing. If a winding up notice is issued against company, it really affects its ability to borrow money, to maintain its credit lines, and to maybe for tender for jobs. So it's like what we discussed earlier. So it disrupts their business. So we can think of bankruptcy and winding up as it's more of a disruption, a threat of disruption to their business operation and lives. And then they come forward with you, and then they try and kind of reach some kind of settlement, hopefully. So whichever you choose, this really depends on the profile of the debtor and what information you know, how they operate, and all that. So that's something that you should discuss with your advisors, your legal advisors, because of course taking any one of these action has costs involved, and you want to make sure you spend your budget, your legal budget, in the most effective way possible. And this is the kind of conversation that you would probably have even before you commence legal proceedings against your debtor. Because it may be the conclusion like this entity or this person simply doesn't have any money. Then really you may not want to even commence anything. But it's not always easy to know for sure how much money a company has, unless and until you get judgment against it, and then you can try examination of judgment debtor. So it's that balancing act that you need to discuss with your advisors. Like, okay, I'm not so sure how much money this party has, but should we spend this kind of money on them? Now, a lot of it is making an educated guess on whether or not the company is able to repay its debts. Now, one of the examples is this company still operating? Does it have employees? Does it maintain a office space? Is it still, are people still coming to work day to day? Now, if there are, then there's a good chance there's still money sloshing through its account somehow. It may not be much, but it shows that the company is trying to stay alive. So timing your litigation is important. Now, you don't want to be the last creditor to take action, because by that time, the company or the individual is basically on the way to bankruptcy. Then there's no chance of getting your money back. But if you're one of the earliest debtors, creditors to take action, then if that company or individual still wants to stay solvent, still wants to operate the business, then they may try to get you your money to block you, so that you don't disrupt their life or their business. So this is something that needs to be considered before taking any kind of commencing any kind of legal proceedings, and before you spend all that money to instruct lawyers and things like that. Because it's no point saying, right, you've got a good claim, let's sue the guy. Maybe $10,000 later, you got judgment. So, and then you didn't think of all these enforcement proceedings, because maybe you've got judgment against somebody who doesn't have any money. So, and it's the job of your legal advisors to begin, I feel, with the end in mind. If I'm going to sue someone, what's my goal? Is it to send a signal to the market, in which case I don't mind if he doesn't have any money? Or am I balancing the cost of litigation and enforcement with the likelihood of getting my money back? Or maybe the plan is to put some pressure and see whether this party will come forward and negotiate it. So these are things to be considered before you commence. It's not just, have I got a good case? It's, is my claim likely to succeed? And just as importantly, can this debtor actually pay me my money? So these are some of the things that you want to think about before you even commence, when you are commencing your debt recovery actions. Okay, so this is a causes of action. Now, this is just a short discussion on, this is something that you should seek legal advice on, really, because it's a very open-ended question where sometimes we get questions that the cause of action is the legal basis of your claim. Now, it's not always apparent to a layperson, because sometimes legal rules prevent certain things, whether or not you actually have a claim against a particular individual or company. So for example, what we get very often is that if a client supplies to a certain company on the basis that they know the boss of the company, and they think he's a reliable guy and he seems to stay in a big house and there's a nice car and there's fancy watches and all that kind of stuff. And so they decide to extend credit to these people, to the company. But then somewhere along the line, unfortunately, the company fails to pay back its debts. And then they say, right, no problem, I'll just go after this guy because he's the boss, we know him, and he signed off on those documents. And so let's just sue him and seize his house if I have to. Unfortunately, that's not always the case, because sometimes in fact, very often, he may this owner of the company may represent that he's got a lot of assets, but the basis of the contract is between his company, which may not even be the main company, which may be a subsidiary company, and people don't verify what we call the counterparty, the other party to the contract. So if you supply goods to a small subsidiary which has no assets and they refuse to pay, You can't go to the parent company, or you can't go to the directors of the company or the shareholders of the company. So this is something that you want to clarify with you want to discuss with your advisors as to who are you actually selling to, who are you actually contracting to. When people look at the contracts, they often skip over the first part, which is this contract is made between party A and B, but it's actually very important because who are you really contracting with? So even for example, let's say you buy a house. Let's say you buy a new house and you see the marketing papers and everything, and it says ABC developer. But when you actually sign the sale and purchase agreement or the option to purchase, it's actually with XYZ development. Now, it's because very often developers set up not small, but separate companies for each project. So you can't say, right, okay, I've gotten the house and it's full of problems and I want to commence an action, I'll just go sue the big guys. You can't always do that. So these are questions of law, and they are very open-ended questions. I think I can't go into too many examples here because we could be here for weeks if we did so. But the idea is that you want to make sure that you have a cause of action for these things. Okay, so bankruptcy and insolvency. So sometimes you are in action where you're in a situation where the company or individual is insolvent. Unfortunately, you can't take any action against them. You can't sue a bankrupt person, or you can't sue an insolvent company. Now, it may seem very obvious, okay, I can't sue, but going back to what we talked about earlier about the cause of action, you want to be careful that you are actually you're entering an agreement with a party that is not bankrupt. It's not something that people think about very often, but excuse me, sometimes you have to verify it before you actually do it. And sometimes we've got clients who want to recover a loan, and then they realize at that point of time that what they've done is actually lent money to a bankrupt person, for example. So they can't take any action, and all they can do is try and complain to the OA or the official assignee and say that this person borrowed money while it was bankrupt. But from a practical point of view, even if the official assignee takes some kind of action against the bankrupt person, even punishes them or whatever, you don't actually get your money back. So this is something actually to think about as well. So what happens if they are bankrupt or insolvent? Unfortunately, all you can do is file proof of that, and then the liquidator will assess the claims, and then you can go from there. But by the time a company is bankrupt, unless it is a very, very large company with assets which are not easy to hive off, most of the time there's not much to get back. So this is something to think about. Okay, debts owed by overseas counterparts. So in Singapore, very often we get clients who are owed debts from, they supply goods or they sell goods to all over the world, Malaysia, Indonesia, the US, all that. The principle is the same. You can still issue a demand letter from Singapore, but you want to look at what is the governing law of the transaction, and whether or not you might need to use overseas lawyers to get your money back. It's really, in this day, it's really not that complicated. It's really not that different. Whether you engage your lawyers in Singapore or you engage them in Malaysia or Indonesia, those lawyers will be able to assist you. Now, one of the key considerations, once again, is to where to commence an action. It's something to be discussed with your legal advisors, but I would say you want to think about where this company has most of its assets as well, because when you talk about enforcement proceedings, about judgments, the Singapore court judgment is effective in Singapore, generally speaking. And you can give effect those enforcement proceedings in Singapore. So if there's assets in Singapore judgment is very useful. But if you have the assets are not in Singapore, like a different part of the world, say Vietnam, then you want to consult and speak with your Vietnamese legal advisors to say, right, okay, I suspect that this company has most of its assets operations in Vietnam. What kind of action can I take? Can I sue them in Vietnam as well? Because if you sue them in Singapore, then you may even get a judgment here in Singapore, but then you have to take that judgment and bring it to Vietnam and maybe start another round of proceedings again. So it's something that you want to think about before you do anything. But there are ways to do it. Of course, there are in certain jurisdictions, the legal system is more stable, it's more well known. For example, if you sue someone in Hong Kong, it's a lot easier than suing someone in Cambodia, for example, where the legal system is not as established as some place in Hong Kong. So this is just a short summary of what I just mentioned. So a lot of these things, a lot of uncertainty arises when you don't have any agreements. What is the purpose of an agreement? Is to set out clearly, when it's going to be paid, what's the governing law, and things like that. So since there's so many different kinds of agreements, let's take a simple one, like an IOU. So what is an IOU? Let's say somebody owes you money, and very often you just say, some people actually this is where being too nice actually works against some of our clients. Now, let's say somebody owes them $100,000, and they very helpfully said, okay, to their friend usually, you don't have to pay me $100,000 at one go. What you can do is you pay me $1,000 every month, and then you just go along with that. And they sign and they actually write out, okay, July 2020 1,000, August 2020 1,000, and they even have this form where they sign off on it once each are paid. Great amount of effort and very well meaning. What happens is the friend pays 1 or 2 installments and stops paying. What happens then? The client comes down and say, right, this guy has paid me $2,000. They owe me $98,000. I would like to sue them for $98,000. And we look at that agreement and we say, okay, yes, he owes you $98,000, but you've got a problem here because the obligation to pay is spread out over 10 years or 9 years or whatever the case may be. So the obligation to pay, you have to wait for each month to go by, to tick by. And then you say, okay, that's $1,000 you haven't paid me, there's $1,000 you haven't paid me, there's $1,000 you haven't paid me. So they, out of goodwill, they made in all this effort to set out these things, but they actually made their claim even more troublesome by dragging it out like that. So you never get this problem if you owe the bank money. Why? Because there's actually a clause in there that says that if you fail to meet any of this in installments, the remainder of the entire debt becomes immediately due. So that's a clause that we rarely see in this homemade IOU things where people just pull it off the internet or something, because they didn't actually think about it. They assume that they're just glad that somebody's agreed to an installment payment. But that's a really important clause. So if you read back on any of your bank, if you ever borrow money from the bank, you'll find that that's actually a clause there. So that's an example of understanding the nature of the transaction and why sometimes you want to get legal professionals to have a look at those agreements. Now, if you're in the business of selling something or lending money or anything like that, these agreements are done once and you can reuse them. So I think it's probably worth the small investment to get those sorted out once, and then you can just reuse them or make minor amendments if necessary, which you can do. But at least you know the structure of it and you have some kind of preview of what are the possible things that might happen.
Jeremy, the first question is, if the company has declared for liquidation, how could we recover the debts?
Right. Okay, so if they are in liquidation, now first thing is, I usually ask my clients is that, who says so? Now this is a real question. Why? Because I've seen cases where the debtor actually says, we are now insolvent and we can't pay you. But they're not. They're actually still insolvent. So you want to do you want to confirm it first. So you do searches for bankruptcy or insolvency, as the case may be, and make sure they're really insolvent first. Because if I am not insolvent and I'm telling everybody insolvent, there's a reason for that. It means I've got money, but I don't want anybody to sue me, so I tell everybody I'm actually bankrupt, which is a good time to sue them actually. So, but if they're really insolvent, then unfortunately you can't sue them. And what you need to do is file a proof of debt. File a proof of debt. So what happens in insolvency or bankruptcy is that the liquidator or the official assignee comes in and he actually steps in the shoes of the company or individual and sees what assets the company or individual has and sees how many creditors he has, and he tries to liquidate those assets and pay off its creditors. Unfortunately, most of the time, by the time it reaches that stage, there's not much money left in the company, and the chances of recovering any money is actually very low, bluntly. So it's not much you can do, unfortunately. So you want to do it early on. You want to wait. If they have voluntarily declared themselves bankrupt or somebody has made them bankrupt, unfortunately, the chances of recovery are low, are very low.
Thank you. So the next question is, the company has been ignoring my notice of payment. What is the next step? Is getting a lawyer necessary?
That's what I called just now the universe of client action, right? So you've tried all your reminders, you called them, even visited them in office. Okay, let me put it like this. If you do what you've always done, then you tend to get what you've always gotten. Now, if you've tried everything, then maybe it's time to try something else. For example, like a legal demand, like a letter of demand. So you have to balance the cost-benefit analysis, right? So what I would suggest is you speak to your lawyer and say, like, this is what is happening. How much would it cost exactly for me to take further action against this debtor? And then balance that with the size of the debt and the chances of recovery as well. So if you've already tried all the notices, then I would say then probably the only option left is to issue a letter of demand. If that doesn't work, then you have to commence legal proceedings against them.
Thank you. Should I go to the small claims tribunals, and what would be the process?
The small claims tribunal has a limit of $20,000 and about 2 years. So you've got to meet those basic requirements first. Then the other thing is that small claims tribunal doesn't hear every single kind of case. For example, defamation case or some kind of personal injury matter, things like that. So, the small claims tribunal may not be able to assist you. So you have to balance that and you try that. And also sometimes this is where really speak to your legal advisors and find out the cost first, because if you go to small claims tribunal, somebody who's familiar with the claim has to go to the small claims tribunal and represent your company. That person has to be, you have got to trust that person to say the right things to the referee, as they call them there, to make sure that the court understands fully your claim. So it's a responsibility. I mean, you can't just pass it to somebody who's relatively junior in your company to go and represent your company at the small claims tribunal. It's still your company, and you want to make sure that the case is presented properly. So more often than not, we find that the boss of the company goes, but it may be quite disruptive to your time. And that's also another reason why sometimes the companies engage lawyers, because it's not that they can't run their own claim. It's that they just want to have somebody else to take over that particular part, so that they can focus on the business. In the same reason why you may engage accountants to check your books. If you do everything yourself, you could, but there's less time for you to do your business development or marketing and things like that. So whether or not to go to small claims tribunal, yes, on the surface, yes, the filing fees are lower and you don't use your lawyers, but you have to balance that the opportunity cost as well. So for smaller claims, then yes, I think you can consider it simple claims. Yes, you can consider it. But that's the balance you wanna take. So what I would say is make an informed decision on it. Check how much time and cost you will need, and then you can decide from there.
So the process will be online, right? If I'm not wrong.
Yes, the submission of documents is, and your claim, you have to write out your summary of your claim as well, is online, but you still need to attend in person sometimes. So the small claims tribunal will give directions and you have to comply with those directions.
How much would a letter of demand cost, and then what will be needed to issue a letter of demand?
So the letter of demand will depend on the cause of action that you're talking about. So let's say it's a very, very simple letter of demand for, like, you supplied goods and they've accepted it without question, they signed off delivery orders, no issue of that. And this could be a couple $100. And then, but something that's more complex there, which relates to, for example, defects, which have like supply of defective goods, which were then installed and then resulted in knock-on effects, because whether or not the goods, whether or not they fault in the components, for example, could have been detected earlier, and then or not, and then let's say they were defective components that could not be checked at the beginning and they failed later, then those demands would be more sophisticated, more complicated, and then we charge more for it, because normally that involves reviewing more contractual documents, more time discussing the case. So then the cost goes up to a few hundred or even a few $1,000s. But for basic stuff, let's say repayment of loans, basic loan agreements, supply of goods, clear-cut cases, couple $100 will be fine. And and for us, we work on, let's say if there's a lot of claims of a similar style, then where we don't have to keep reviewing contractual documents, then we can operate on a bulk kind of arrangement as well. So speak to a legal advisor on the nature of it. I think most lawyers are quite happy to discuss it, to at least understand the basis of it, and then they can get a better idea of how much it will cost.
Okay, thank you. The next question is, what if my ex-employer did not pay my salary? So the process is the same?
Sorry, please say that again.
When their ex-employer did not pay their salary.
Okay,
so the process of the recovery is the same?
Broadly speaking, it can be the same, but there exists also avenues for lower income salaries employees to go to MOM and commence an action, because they actually make a cap of the total amount that they can claim. I think it's about $20,000 in the MOM employment tribunals. Now, if you're a very senior employee and you owe hundreds of thousands of dollars, then you have to go through the court system. So, but broadly speaking, it's the similar thing. You start with the formal demand for the payment, and then if they don't pay you, then you might need to commence an action against the company. Employment disputes are a little bit more nuanced. I mean, we don't really want to encourage a lot of these fights. I mean, there's a lot of room for negotiation for these things, because what we found is that courts are nowadays quite sympathetic towards unpaid salaries, especially if it's clearly set out. Like, if you've signed an employment agreement, then it's not easily justified to make deduction from that. So they are quite a specific area of law, and for that, really speak to a legal advisor, because there are some nuances that are better discussed, which are fact specific, so specific to that general circumstance. I mean, it's a sale of goods. If you sell a tractor or you sell mobile phones, you can see it almost in the same way, but for unpaid salary as opposed to unpaid debt, there are nuances. So I would reserve my position on that. Yeah.
Is debt collection agency legit? And what happens if they do something wrong or illegal when collecting the debt? Does it impact the ones who appoint them?
Right. So debt collection agencies are legit. You are perfectly entitled to use them, and for other companies to use them against you. What happens sometimes we found is that these debt collection agencies, they don't actually analyze your claim. Now, lawyers are obliged to look at your claim when you come to them and say, right, this person owes you money. We are obliged to at least have an initial view on your claim, and do we agree that there's a legal basis for that claim before we can issue it under letterhead. So when a law firm issues a letter of demand, they are in fact saying, I have looked at the facts of this matter, and in principle, I agree there's a legal cause of action against the debtor. I'm pretty sure that the debt collection agencies are not obliged to go through this vigorous process, because they just say, right, okay, you tell me this guy owes you $50,000. I write $50,000 on my demand and I just send it over there and I demand $50,000. There's no assessment of that claim. There's no advisory on that claim. So what we have seen very often is that clients come to us and say, right, this guy is demanding $50,000 from me. I don't owe him this money at all. And these debt collectors are not listening to me. And it causes a lot of unhappiness there. And when we respond on behalf of these debtors, and they say, and then the debt collection agencies just go silent quite often. And I think if you were on the other end of it, then you felt like, well, hang on, this all could have been clarified if I'd been advised properly on whether or not I'm even entitled to claim this amount of money. So that's something like that, because a lawyer cannot just blindly accept what the client says. Like, I want to sue this guy for being a very nasty person, for example. You can't. And the lawyer is bound by duty to tell you that you can't. So you can, so the starting point is, yes, these are legitimate ways to try and get your money back. Now, what happens if the debt collection agencies does something illegal? Now, it's not common because most of them are quite careful not to cross the line. But there is this thing called vicarious liability, where the owner or the employer can be made responsible for the actions of its agents. In this case, the debt collection agency. It's not an easy thing to prove, because normally there are certain legal rules as to why. I don't think it's probably going to be the case, because they are probably seen as probably known as independent contractors. But you can run the risk of it. Okay, for example, you to take an extreme example to understand, so that it's a bit more clearer, is that, let's say I hire someone to kill someone. That's an illegal thing, obviously. Now, I can't say, oh, no, I'm just an independent contractor, and he's an independent contractor, it's none of my business. Now, if you engage the debt collector with the intention to commit some illegal acts, and you somehow knew that they were going to, I don't know, threaten their family or something like that, then you may have liability. You may have. And there's also things that, for example, what happens is the debt collection agency goes to the shop and it sticks all kinds of notices outside the shop. And then they take photos of it in an effort to name and shame them. And then the client also takes those photos and starts spreading it there all around. That may be defamatory, for example. So, and that may be, by publishing those images, you may get yourself involved in liability as well. So you want to be careful what you kind of action you take in this open forum or something like that. So the short answer is, yes, they are legitimate, and yes, although unlikely, I must say it's unlikely, you may be responsible for the actions that these agencies take. But in our experience, we don't think they're particularly effective, but they're mostly careful enough not to cross the line. I know there's been some publicized cases where they went to one agency went to a food court to actually threaten one of the store owners, and they ended up being arrested. I think that actually is quite unusual now. I think they're a lot more careful now.
Thank you. The next question is, I'm confused on the new law passed by the government for the COVID measures. Does it mean my customer doesn't need to pay me according to the contractual term anymore?
Okay, that's quite a general question. There are very specific provisions in the COVID-19 temporary provisions bill that was passed earlier this year, a few months ago, in response to the pandemic. So you need to look at what is the nature of that contract. Sometimes whether it's a commercial tenancy contract, or was it for sale of goods, or was it for rental of construction machinery. So there were various specific categories and various what we call moratoriums. So you can't take action. So it's not to say that no need to pay. It means moratorium means don't pay first. Later, then we sort it out. So it's we've analyzed that bill. It doesn't cancel any obligations per se, unless it's been clear cut, like, okay, you're allowed to set off rental for a property tax rebate, something along those lines. So there's still some uncertainty as to how those provisions will play out, and because it's still very new, and this is how new laws evolve, I interpreted. So there hasn't been a lot of litigation over the temporary provisions itself. So I can't answer that question generally, because the law, that particular law actually provides very specific provisions for different kind of contracts. So I think that's something that we have to take up possibly offline.
Thank you.
But in general, it's there's what we found, that there's no blanket cancellation of legal obligations. Meaning to say, if you were obliged to pay rent, you can defer it. But the law does not go, that particular law did not go so far to say for that month you don't have to pay at all.
Thank you. Any advice on payment collection from overseas customers like Vietnam and Bangladesh?
Right. So we touched upon this briefly just now. So the basic process is the same. That you send your reminders, you call them, maybe even fly them, visit them. Hopefully they pay. What you still want to do is a letter before action. You issue a letter of demand, and it can't come from Singapore in case you don't want to go all the way to Bangladesh or Vietnam to look for a law firm, and then see what the response is. As mentioned in the beginning, it's a dynamic process. You take one action and you see how the other side responds. So we've issued letters of demand all over the world, Hong Kong, France, and everything. More often than not, depending on the we do get a response actually.
Yeah. Can I get my debtor to pay all the legal fees?
Yes, you can, if they agree to, but let's say they don't agree to pay your legal fees, then what can you get? So you can get what is awarded to you by the court if you sue them, and the court will award you a certain amount in terms of costs. Now, you can always include it in your settlement proposal and say, right, I've spent $500 on letter of demand, and I will only settle if you pay me the amount you owe me plus this $500. Yes, you can say that. But you can always say, you can say anything you want, but the thing to consider is, will the court back you up? Will the court say, pay $500 on top of the amount that you owe? The answer actually is no, because what is the basis for that $500? It's not something that's agreed in contract. It's legal costs, and legal costs are assessed on a scale that you have in court.
Thank you.
So you can't always recover every single cent. Yeah.
When serving notice, can we serve it to the residents of the shareholders or directors?
Okay, I'm going to assume that this is a claim against a company. Generally, yes, you can actually serve it against the directors, because they are seen as officers of the company. So there are various options. In addition to the registered office of the company, you can also serve it on directors, but generally not the shareholders.
What can be done if the debtor has disappeared, changed address, changed job, no contact number, and no response from email address?
Yeah, so this is something that we discussed earlier as well. So where you find it very difficult to locate this person, remember that the court doesn't actually investigate cases for you. They don't collect evidence for you. That's something we've got to do ourselves. So we have to find out as much information as we can on this person, or this entity, before we even extend the credit. So I would say, by that time, you're trying to look for information after the fact is very difficult and very costly. So anytime you're going to lend money or extend credit to someone, you want to find a way to make sure that they can remain contactable. Now, if there is no way that you can ensure this, then I would say, don't extend too much credit. That's the best way to do it. This is why you want to plan out your actions before you actually extend the money over. So sometimes you hear lawyers talking about possession being 9/10 of the law. What that means is that until you hand over the money or the goods, the risk to you is very small. When you hand it over to them and trying to get it back, it's always a lot more difficult. So you want to assess that risk before you even hand that money over. So whether is it IOU or is it giving credit for supply of goods, you want to ask these questions before you actually go into it. So that's one way, but of course that's on hindsight. But if you have it now, if you have that problem now, you have to try different things like searching for private investigators, credit investigators, but these are quite expensive. I mean, they run into several $1,000s just to start. We can try basic searches to see if anything comes up. But if you're talking about someone who has like no job, no house to their name, and nothing, then unfortunately that recovery in that process is going to be very, very difficult. And even if it's possible, it may not be worth the cost of investigating these people.
Okay, thank you. What if the settlement does not follow through?
So settlement meaning like they offer to enter into some kind of deal with you, and then they eventually don't pay. So that settlement agreement has to have certain provisions to say that you can demand and sue them for the remainder money. Okay, now why is this useful? So sometimes you have a supply of goods this claim against a debtor. You said you sold them something and then they haven't paid you. Now, what's a common strategy for the debtor is to say, okay, I received this goods, but actually there were all these problems with this goods, so I don't have to pay you the full amount. So that's a dispute in itself, and it's enough to muddy the waters to try and cut down your claim and dissuade you from proceeding. Now, if you get a settlement agreement, what you want is to fix that settlement sum so that you don't have to sue on the sale of goods, but you can sue on the settlement agreement, say that you agreed to pay me X amount of dollars, pay me, that's it. So it makes your claim a lot easier. So that's a useful thing to have, even if they don't pay you subsequently. So that's why for a lot of disputes, we still want to push through a settlement agreement, even if the client says, this guy is not going to pay me. Because it makes it a lot easier to prove your claim. Then you can just worry about enforcement. So enforcement, we keep coming back to it. Okay, what information do we have on his assets? What do we know? Anything about where their money is? Are they still operating? Sometimes when you enter a settlement agreement with a company, what you want to do as well is to try and see whether they will sign a personal guarantee, or the director, so you can try and pin them down more easily.
After getting a default judgment, can we proceed to apply for bankruptcy on the company?
Yes, you can, if you exceed the threshold for the winding up. So it's been increased to about $200,000 now. I think, sorry, $100,000 now for companies. So you need a minimum threshold. So this is the effect of the COVID-19 bills as well. It's been increased to a bigger threshold of this amount. So, but the answer is yes, you can commence bankruptcy proceedings. Winding up proceedings against the company.
I know that the company's owner is rich, but he still neglect the payment notice and he liquidated his company to avoid debt. What can I do to him?
Okay. When clients ask this question, what they're really saying often is that they suspect that there's money in the company which has been somehow taken out from the company and the owner paid himself unfairly. Now, if it was money, and because it was money that is legitimately paid out the company, let's say in the form of dividends or directors' fees or salaries and things like that, you can't go after that individual director. But let's say that this director somehow transferred a lot of money out without any basis from the company in an effort to defeat the company's creditors. Then yes, you can pursue this action by saying that by winding up the company and then going through the books of the company and finding out if there were any what we call transactions at undervalue. So means that if the company just basically transferred $1 million out to its director for no reason, that may be deemed as a transaction undervalue because it was an attempt to take out money from the company so that its creditors don't get paid. There exists actions to claw back that money from the directors. Now, this is a lengthy and expensive process. So unless you're talking about hundreds and thousands of millions of dollars, and we have actually some proof that this happened, it doesn't happen very often. I mean, people don't pursue it very often. So if it's like, for example, what happens, like let's say you supply machinery at $50,000 and you don't get paid, but like I said, the owner is still rolling around in a nice Mercedes Benz. It's not going to be easy to trace that money back to the owner. So the starting point is that companies have what we call separate legal personalities from their owners. So if you contract with a company, you supply goods to that company, you can only go after the company. And it's very difficult for you to go against the owner of the company, shareholder or director's company, unless you can prove that this owner has cheated you, has committed a fraud against you. Fraud is not easy to establish, and if you suspect it, then you need to have evidence of it for sure, and then you should bring that evidence and consult specific legal advice on it, because it's very fact specific. So we need to look at it and see whether that's sufficient to prove that there was fraud involved. But otherwise, generally, you can't go against the owner. So you want to be careful about that. If you're going to supply a substantial amount of goods or credit, or offer up credit to these people, then you might want them to sign a personal guarantee, because you are really giving that trust based on that individual, and then that person, if you want them to take personal responsibility for it, you should get them to sign a personal guarantee.
Thank you. Can we do a small claims tribunal against a debtor who has passed away?
I don't believe that the small claims tribunal will allow such a claim to go forward, because what you're making a claim is for the estate of you can claim against someone who's passed away, you can claim against his estate, but they probably need to be represented by lawyers and executors. So I don't think that's the kind of claim that the small claim tribunal generally hears.
I have a dispute with a client in construction. So I used to send letter of demands, and there's also risk. Will getting a larger law firm to act prompt them into taking positive steps to resolve, as they could use their small law firms to bleed you?
In Singapore, when you commence an action in court, the court looks at your claim and your evidence, and it doesn't look at the lawyer that you engage. So I don't think it makes a huge amount of difference, as long as you've got a good lawyer, whether he's from a small firm or a big firm. It's got to be someone who understands your business, understands your goals, and of course the fees that you will negotiate with a lawyer has to be acceptable to you. Some people set higher prices for their work, and that's the freedom that everybody has to contract. So I don't think the size of the firm is determinative. I think the quality of the legal advice they receive can come from both big and small firms. There are small firms with very, very good lawyers, and there are big firms with very, very good lawyers. So that's something that you should your lawyer is going to be very important, because you will be relying on them to give you very objective advice, not to waste your money on unnecessary actions. So interview a lawyer and try and make a judgment on their intentions. But I don't think size alone will tell you that much about the quality of the legal advice that you receive.
When you do the garnishee procedure, if we do not know which bank account they have, can we write into all the banks?
You can, but you won't probably get an answer. So because these things are quite private, generally the banks don't disclose that kind of information. So unfortunately, or there are other ways to do it. For example, there's usually some form of a business relationship even before this one, unless it's really the very first one, then okay, tough. But let's say previously you have received payment from this party, then you can use that check or that transfer thing as a way to establish which bank account that they have. So you don't need a specific bank account number, but you need to know at least the bank that they use, and you need to provide this evidence to court to show that, right, this is how I know that this company has an account with DBS Bank, for example. So it can be part of your purchase order or invoice, and where they have to fill in their bank account so that there is something. Yeah.
Once the court judged our favor, can we apply for garnishee immediately? And what if the bank account is empty? Is there any way you can check that on the debtor bank account? I think the last question you've already answered.
So
apply for garnishee immediately, and what if the bank account is empty?
You're obliged to give them a small amount of time to make payment on judgment. It's about a week generally, not very long in the grand scheme of things. So not immediately. Usually you give them a reasonable amount of time. A week is sufficient. And what happens if there's no money in the bank account? So unfortunately, if there's no money in the bank account, there's nothing to seize. You don't get any money, but you still get what we call awarded costs. So for that particular garnishee application, you may get cost of a few $1,000s, for example. You can claim from it later if you take out other enforcement action.
So
okay, so just to add on, let's say the debt is $10,000 and there's only $5,000. So you can only take the $5,000 and then you have to try something else later. If the account has $100,000, then you just take out your $10,000 and plus cost and everything, and then you that's it.
Are the enforcement proceedings the same for all the courts, especially the small claim tribunals?
Generally, yes. So no matter whether it's a judgment for $100,000, $1 million, $5, the enforcement procedure is the same.
If a debtor owes us some money and did not pay and is beyond the valid period of 6 years, yet we still send them demands and letters, what can the debtors do to us besides paying us? Can they sue us for harassments?
Okay. Let's say it's expired and then you keep harassing them. Now, harassment, you can understand it as a matter of degree, right? If you call someone once, a phone call, there's not going to be harassment. In a day you call once, no. Twice, probably not. 100 times, yes. You can see that it's not a predetermined like number that you hit that constitutes harassment. If they actually take on an application against you for harassment, then they have to show a pattern of behavior that's intending to cause that kind of distress to a person. It is a balancing act as to how many times you call, and the court will never say the magic number is 29 calls, for example, and then over there it's always looked at in the totality of things. As a law firm, we don't do this kind of thing. Why? Because it's not generally effective, firstly, and you issue a letter of demand, and what is the message behind it? It's like, this is your last chance to respond to it. Now, if you don't respond to it, I'm going to sue you. But now when you commence legal action against a party, you serve the papers on them, you wait, give them the time to respond. If you don't respond, you get judgment. You don't waste your time calling them 20 times a day. You get judgment and you take enforcement action by sending the bailiff to their home or seizing the bank account or something like that. So it is decisive, right? It goes like, okay, this, then this, then this. But I mean, when you're making multiple phone calls, sending a lot of letters, it's all too easy to ignore them. And not only they can be ignored, you run the risk of getting a complaint of harassment against you. Whereas if you take legal action like that, there is a finality to it. And if you track down the assets, you take it without asking. Now, no matter how many times you call, it's still ultimately depending on that debtor coming forward to offer you the payment, whether because they're afraid or they're just sick of it. But you never actually take it from them. They have to hand it over. Now, whether or not you persuade them or you put pressure on them and hand it over, that act of handing over is still within their control. Now, that's very different from the bailiff coming to see something. It takes without any reference to them. So that's something to think about.
Thank you. If the company keep ignoring our notices, can we call them out in public, like posting it on social media? Will that count as defamation or something illegal?
So this recourse to mass media is something that is frankly out of the expertise of a law firm. But generally speaking, we don't recommend it because social media, mass media is a very open-ended question and it's a very two-edged sword. And you never know how your particular circumstance can be spun. And it always opens you up to the risk of a retaliatory defamation claim. So I generally do not recommend that you post all such things on social media because you have very, very little control over it.
Thank you. We have a commercial property rented out to the sole proprietor. Contract is due to expire August this year. Tenant has defaulted payment since February. What are the course of action to take up after August? And the tenant is also saying that the COVID temporary measures, the tenant is making use of the COVID temporary regulation to default payment. So what is the legal action we can take to recover this amount? It's about not more than 15K.
Well, so generally the provisions do not say that you don't need to pay ever. It just puts postpones the payment to later. So I don't think the provisions went so far as to say you do not need to pay. There might be some rebates and discounts that the government gives, but that's really something that needs to be worked out in relation to property tax and all, and then like grants that I think the government is offering to qualifying landlords. But from a pure contractual perspective, now even if they don't have to pay in the last few months, it doesn't mean that they don't ever need to pay. So that's what I meant when we said there's a moratorium on it. So we need to look at the nature of the contract and whether there's any provisions, whether anything was discussed in between. But generally speaking, you still have to pay.
I would like to inquire on examination of judgment debtor. If the debtor is a private limited, this judgment only examines the company, and what about the company directors?
Yes, so the examination of judgment debtor is only against the company's account. So the directors of the companies can be summoned and they have to provide information, but only in relation to the company's account, so not their personal assets.
Thank you. Company, which one is good? Company bankruptcy or personal bankruptcy, and what's the difference when it comes to winding up in case of private limited, sole proprietorship or partnership?
So you can't compare it like that because the first question is who's the debtor, who's the person who actually owes you money. It's either the company or the individual, unless the individual gave a personal guarantee or what. So it's not like one is better than the other. It's what you are entitled to take out. So you can't compare it like that. But the overall effect is similar. Like the assets are vested in the company in the liquidator. So I think there are various strategies to it. For example, but I think generally personal bankruptcy tends to be more disruptive because ultimately companies can be created and many and wound up, and there's no human behind it. Ultimately it's the humans behind it which are really the ones that we are after. So generally, if you can, the opportunity arises to go after the individual or the company, most creditors would choose the individual. You put more pressure on them that way.
If I'm a creditor to a company and there's another creditor that commences action, is there anything I can do to protect my position or prevent that other creditor from cleaning out the company's assets?
So in this case, we're assuming that you're not what we call a secured creditor. So secured creditors are like banks who hold charges over machinery or property, things like that. But if you are what we call an unsecured creditor, then there's nothing you can do to hold on to a certain part of asset because somebody sued first. So, which is why earlier on during the discussion, the talk was, you want to be the first one to sue when there's as much assets as possible. I mean, when the company is not doing well, not paying its creditors, you can assume that its equity position is going down. So the longer you wait, then while everybody is sort of grabbing their own share or they're settling with everybody, then by the time it comes to you, then there might not be anything much left. Yeah.
For private limited companies, is the debt limited to the paid up capital? And will the business owners or the directors be liable for the debt?
Okay, so the name private limited company means that it's not limited to the paid up capital. The company can be liable for whatever millions that it incurs, but limited meaning to say that it doesn't, the members of the company, the directors and shareholders, are not personally liable for the debts of the company, unless, and this is a big unless, there has been fraud that's been committed by the directors, and you need to be able to prove fraud, and it's not easy, I can assure you.
So will it be advisable for them to do a background check on the company first before dealing with them?
Well, I suppose it's a balancing act, right? If you're going to, it's what size deal you're going to enter into this company. If you're going to extend credit of millions of dollars, then of course, yes, absolutely. But if it's a relatively small amount to the kind of the size of the company, then it's maybe not worth the cost. So it's something that you balance the cost. I mean, ideally, you want to know everything about every single debtor that comes along, or every single customer that comes along, but it's just not commercially viable. So you assess the amount of credit that you're extending to this company, and then maybe when you need more, then you say, right, okay, we need to review this, and we need more information. Or if you want us to continue extending credit, one of your directors or all your directors might sign personal guarantees to make sure that I can get my money back. So that's actually, I mean, how you can use the banks as an example. So if you borrowed a few $1,000s from DBS, they do basic checks. If you borrow 500,000, they want more. They want more information. They want to know income. They want to know all this kind of thing. And then if you want to borrow millions, then you have to put up security, for example. So you want to be careful about how much credit you're extending to these people. So I think one way to understand it is that as long as you don't get paid upfront for your goods, you are extending credit to this entity or this person, and credit is a loan, essentially. That's what it is. So what's the chance for you to get so are you comfortable as a business lending this company this amount of money? Now, if you're not, or you want to know more information before you do, then I believe it's perfectly acceptable for you to ask for the information.
The next question is, an old friend took a 40K loan from my family, and we have only an old document stating that he took that loan from nearly 20 years ago. Is that still something we can do?
So if it's a loan from 20 years ago, then there's a pretty good chance, and we should look at a document, there's a pretty good chance that the limitation period of 6 years has elapsed, okay, which means that you've lost the right to sue. Now, this sometimes happens, and what we do is we try to sort of bait the debtor into admitting to a new debt, and then so that you sort of revive the action. So we've done this for our clients before, and where they sort of create a new set of obligations. So it could be like, okay, that was $40,000. And then you call them up in some kind of recording or what, and you say, okay, remember that $40,000? And they go like, maybe they admit it, maybe they don't. But you get them in a conversation about it, and then you say, okay, instead of $40,000, why don't we agree that you pay us back $20,000? And then he says, right, okay, I'll pay you $20,000. And that creates a fresh set of obligations, new for 2020. And then at least you have something new that you can sue on. So that old debt, because it was too long ago, can't sue anymore. But there's a new debt of $20,000 now, which is better than zero, I guess. So that's one way to work on it. But it's something that we need to understand a little bit more about the facts. And you also, but it's a weak position. That's the reality of it. So you have to factor in that it may not, the debtor may just keep denying everything, and it's very difficult for you to create a new set of obligations.
Thank you. We have enough time for another about 2 questions, but I can see that there's actually about another 39 questions that is here. From what I see, perhaps when you receive the recording from SCCCI, you can look into the session again, because if I'm not wrong, what Jeremy shared, right? Some of your questions are actually answered in the presentation earlier. However, I did leave Jeremy's email and also our website address for you all to contact us if there's any other pressing questions that you have. So we have another about 2-3 minutes. Let's try to answer another 2 questions. If we get our customer to sign a guarantee letter, does it need to be endorsed by a lawyer to have it to have legal impact?
No, you don't need to. You don't need to be a lawyer to witness these things. Ideally, you get a some third party person to witness it, but it's not strictly necessary. So the witnessing of a document is only with a dispute as to somebody says, I didn't sign this document. So you don't need to be a lawyer to confirm it. So the answer is no, you don't have to.
Any incidents where the cost of legal proceedings ended up higher than the sum to be recovered?
Yes, of course, they do, which is why this is something that you should discuss with your legal advisors before you even commence. How much is it going to cost? Both in terms of time and money. So it's something to consider, because, I mean, if you think about a $5,000 claim in the magistrate's court, the cost of pursuing it all the way is not really going to be radically different from a $50,000 claim, unfortunately. Because so there's a minimum threshold by the time you start working on a matter that you have to overcome before it becomes worthwhile. So if the claim is really small, I mean, $50, for example, yes, of course, the cost will far exceed, and that's unfortunately the limitations of the how many cases a lawyer or a judge can hear in their lifetime. Yeah, so there's going to be a minimum cost involved with it. That's the reality of the situation. For those smaller amounts, that's where you can try the small claims tribunals, where they try to make it simpler, try to make it more, I'm not really sure if it makes it faster, but I would say that you can try it. It's not as if the courts are intentionally making the civil litigation system more difficult than it has to be. I think every day you will see, if you speak to any lawyer, the courts are always trying to streamline the process, always trying to make it more efficient. There is downward pressure on legal fees. It's a competitive market. I don't think anyone can get away with doing unnecessary things. So I think as time goes by, you'll find that there's just a minimum cost to doing things.